Hey everyone, welcome back. If you're new here, grab a blanket, dim the lights, maybe put on that fan you've been using as white noise since 2019 and settle in. We're going to be here for a while tonight, and that's kind of the whole point. Tonight's topic is one of those quiet little corners of history that doesn't get nearly enough attention. It's not a war, it's not a plague, it's not a famous king doing something dramatically stupid, although, fair warning, there are a few of those in here too, because there always are. Tonight we're talking about women who were declared legally dead. Not actually dead, not even close to dead in most cases, just legally dead. Declared so by a court or a church or a husband with very convenient paperwork and an even more convenient new fiancé waiting in the wings. We're going to drift through medieval Europe, through the courts of England and France and the Holy Roman Empire, through canon law and civil law, and the kind of legal grey areas that would make a modern attorney physically ill. We're going to meet women who were erased from the legal record while they were still very much breathing, eating, and in some cases, absolutely furious about the whole situation. Some of them fought back. Some of them disappeared into convents or remarried under different names or simply wandered off into a historical footnote and never came back. Some of them haunted their husbands in court for decades afterward, which is honestly the most understandable response. This is not a fast story. It doesn't need to be. History, when you let it, moves slowly and strangely, like a river that keeps changing course just when you think you know where it's going. So let's begin. Let's drift back, very gently, to a world where your legal existence was roughly as stable as a wet piece of parchment.
To understand how a living woman could be declared legally dead, you first need to understand what legal personhood actually meant for women in medieval and early modern Europe. And the honest answer is, not very much. A woman's legal identity in most of medieval Europe was, to put it delicately, conditional. It depended almost entirely on her relationship to a man. Specifically, which man was currently in charge of her. Before marriage, a woman existed legally as an extension of her father. She could not own property independently in most jurisdictions. She could not sign contracts. She could not appear in court on her own behalf in most cases. She was, in the eyes of the law, something between a person and a very valuable piece of furniture. After marriage, she became what English common law called a femme covert, covered, hidden, legally absorbed into her husband's identity. The two became, technically, one person, and that one person was, naturally, the husband. This wasn't considered cruel or unusual at the time. It was just the way things worked. A wife's legal existence merged with her husband's the way a small river merges into a larger one. She didn't disappear exactly. She just became part of something that had his name on it. Now, here's where it gets interesting. If a woman's legal identity was already so thoroughly tangled up in her husband's existence, what happened when she was removed from that equation entirely? What happened when she was sent away? What happened when she vanished? What happened, most relevantly for tonight, when her husband simply decided she was gone and the law agreed?
Let's talk about the concept of civil death first, because it's the foundation of everything we're going to explore tonight. Civil death, or mort civile in French legal tradition, was a legal status applied to people who were considered, for practical purposes, to be dead to society, even if they were still technically breathing. It applied most commonly to three groups of people. First, criminals who had been condemned to severe punishment, a man sentenced to life imprisonment or to exile, or to certain forms of corporal punishment, could be declared civilly dead. His property would pass to his heirs. His wife could remarry. His debts were handled as though he had died naturally. He was, legally speaking, no longer a participant in society. Second, And this is the one that most people know about: people who entered religious life. When a person took solemn vows in a monastery or convent, they were understood to have died to the world. Their earthly life was over, their property transferred, their marriages were dissolved. They were alive in the eyes of God, presumably, but dead in the eyes of the law. Third and most quietly devastating, people who simply disappeared. In an era before photographs, before national records, before any reliable way of tracking where a person had gone, disappearance was a legal problem with no clean solution. If a man left on a crusade and didn't come back, was his wife a widow? If a woman was taken captive and transported to another country, was her husband still married? The law needed answers, and the answers it came up with were, as you might expect, deeply tilted toward whoever was left behind with property to manage.
In English common law, a legal doctrine existed called the presumption of death. The basic principle was simple. If a person had been absent and unheard from for a sufficient period of time, they could be legally presumed dead. The length of that period varied across time and jurisdiction, but the most commonly cited standard, which eventually solidified into the 7-year rule that still influences some modern legal systems, was roughly 7 years of unexplained absence. 7 years of silence, and the law would shrug and say, well, probably dead. This seems reasonable enough on the surface, and in many cases it was genuinely practical. People did die on long journeys. People did disappear into wars or famines or the simple chaos of medieval travel. And their families needed legal clarity to move forward. But here's the thing about practical rules when applied to people with money and power and very motivated spouses waiting at home. They get abused. Spectacularly, creatively, and with remarkable frequency. The machinery of disappearance into death was not complicated. A husband who wanted to be rid of his wife had a few options available to him, depending on his resources and his patience. He could simply wait, send her somewhere remote, a distant estate, a convent framed as a retreat rather than a permanent arrangement, and then simply stop sending letters, stop acknowledging her existence, allow the silence to accumulate year by year until the legal threshold was reached and he could present himself to the appropriate court as a man in the genuinely tragic position of not knowing whether his wife was alive or dead.
He could, if he had friends in the church, arrange for an annulment on grounds that were technically legitimate but practically manufactured. The grounds for annulment in canon law were numerous, and with the right arguments and the right donations to the right parties. Surprisingly flexible. He could, if he had access to civil courts and the ear of a cooperative judge, petition for a declaration of presumed death outright. The required evidence was thin. A few witnesses to say yes, she left, we haven't seen her since. A statement of genuine uncertainty, a modest bribe in the appropriate direction sometimes, though not always. And then it was done. His wife, still alive somewhere, perhaps in a convent she had been deposited in under the gentle fiction of a temporary spiritual retreat, was legally dead. Her property reverted to him or to her father's estate, depending on the terms of her original marriage settlement. He was free to remarry. She was, legally speaking, nobody. What makes this history so quietly strange is how varied the outcomes were. Some of these women simply accepted their new status. They had been placed in convents, after all, and convent life, particularly in an enclosed community with other women, was not universally miserable. It offered literacy in many cases, community, a degree of stability. Some women who were deposited into religious houses by inconvenient husbands found that they actually preferred it, which is a small irony that history tends to overlook. Some women died before the question ever became urgent. Mortality in medieval Europe was not discriminating. A woman placed in a convent at 30 might simply not survive long enough to ever challenge the situation. but some of them did survive. And some of those survivors had opinions, strong ones. And the records of what happened when a legally dead woman decided to be inconveniently alive again are, to put it gently, some of the most quietly entertaining documents in the entire medieval legal archive. Let's settle in a little more and drift over to one of the most vivid examples of this phenomenon, because it happens to involve a woman with more backbone than the entire court of Henry II. And it is a perfect place to begin. We are going to talk about Eleanor of Aquitaine. Now, Eleanor is not technically an example of a woman declared legally dead. She was declared imprisoned, which is adjacent. But what happened to her legal status during those 16 years of captivity in various English towers is relevant to everything we're going to talk about tonight, and she is too wonderful a starting point to skip. Eleanor of Aquitaine was, by any reasonable historical measure, the most powerful woman in 12th century Europe. She was the Duchess of Aquitaine in her own right, which meant she controlled a territory in southwestern France larger than the Kingdom of France itself. She had been Queen of France briefly before that marriage collapsed in what can only be described as a spectacularly mutual disappointment. She then became Queen of England by marrying Henry II, which was either an upgrade or a lateral move depending on your feelings about Henry II. And the feelings about Henry II were mixed. She bore him 8 children. She governed significant portions of his empire. She managed her own court at Poitiers, which became one of the great cultural centers of the 12th century, associated with the development of courtly love poetry and the kind of sophisticated literary culture that Henry II, who was more interested in hunting and shouting at bishops, had very little patience for. And then, in 1173, she backed her sons in a revolt against her husband, which was bold. It did not go well. Henry captured her, deposited her in a series of comfortable but firmly locked royal residences, and kept her there off and on for the next 16 years. Now, Eleanor was not declared dead. She was too famous, too well connected, and too thoroughly inconvenient to disappear from the legal record entirely. But her political and legal identity was effectively suspended for those 16 years. She couldn't govern, she couldn't sign documents, she couldn't conduct diplomacy or manage her own estates. She existed, technically, but she was legally inert. And the moment Henry died in 1189 and her son Richard became king and sent someone to release her, Eleanor of Aquitaine, who was now approximately 67 years old, walked out of captivity and immediately began governing England as regent while Richard went off on his crusade, as though no time had passed at all, as though 16 years of legal suspension had been, at most, a mild inconvenience. Eleanor is in many ways the patron saint of tonight's topic, because she represents what was theoretically possible when a legally erased woman had the resources, the connections, and the sheer personal force to reclaim herself. Most women did not have Eleanor's resources, most women did not have Eleanor's connections, and most women frankly did not have Eleanor's particular brand of extremely focused stubbornness, but some of them tried anyway. And we'll get to them shortly. For now, let's let Eleanor settle in as our opening image, an old woman stepping out of a locked door and immediately getting back to work. It is, all things considered, a very good image. Before we get to individual women and their individual disasters, we need to spend a little time with the institution that controlled the legal fate of most marriages in medieval Europe, the Catholic Church. Specifically, we need to understand canon law, which was the body of church law governing marriage, and which was, to put it charitably, a document of extraordinary ambiguity that managed to simultaneously insist on the absolute permanence of marriage and provide approximately 17 different ways to dissolve one if you knew the right arguments and had access to the right clerics. Canon law held that marriage was a sacrament, sacred, ordained by God, indissoluble, and then it provided the concept of annulment, which was the legal determination that a marriage had never actually been valid to begin with, which was technically not the same as dissolving a valid marriage, even if the practical result was identical. The grounds for annulment under canon law were numerous, and in the hands of motivated petitioners, remarkably elastic. Consanguinity. If the couple were related within a prohibited degree, the marriage was invalid. The prohibited degrees were calculated so broadly in early medieval law that in a society where noble families intermarried constantly, almost any marriage could theoretically be challenged on these grounds if someone looked hard enough at the genealogy. Prior contract. If either party had been previously betrothed or married, and that earlier arrangement had not been properly dissolved, the later marriage was invalid. Lack of consent. If either party had not genuinely consented to the marriage, it was invalid. This one is interesting because it sounds protective of women, and occasionally it was. But it was also used by husbands who needed a way out by claiming that their wife had been under duress, or that some technical irregularity in the original ceremony had made proper consent impossible. Impotence. If the husband was impotent and the marriage had never been consummated, it could be annulled. This required, in some jurisdictions, what the records delicately describe as an examination by witnesses, who would confirm the relevant facts. Medical history is full of moments that make you grateful to live in a later century, and this is one of them. And then there was the most expansively useful ground of all, error of person. If one party had been deceived about the fundamental identity or status of the other, the marriage was invalid. This sounds specific. In practice, it was not.
The relationship between civil death and ecclesiastical annulment was one of the more tangled administrative arrangements in medieval legal history, and it produced outcomes that, when you trace them in the records, have a quality of slow-motion catastrophe that is almost hypnotic. Here is the basic problem. Civil law and canon law operated simultaneously, but not always in harmony. A woman could be legally dead under civil law, her property distributed, her husband remarried under civil authority, while canon law still considered her the legitimate wife of that husband. This created situations where a man had two wives, one civil, one ecclesiastical, which sounds like a theological headache, and it was. The church did not approve of bigamy. The church also did not always have perfect information about what civil courts were doing in distant provinces, and the church's annulment process, while theoretically rigorous, was in practice as susceptible to influence and incomplete information as any other institution of its era. So you got situations where a woman had been declared civilly dead, her husband had obtained a civil remarriage, and the church was operating on the assumption that the original marriage was still canonically valid. And then the first wife reappeared, and everyone involved had a very uncomfortable meeting. Let's drift over to France for a moment, because France provides some of the richest examples of this particular tangle. The French legal tradition, drawing on both Roman law in the south and customary law in the north, had a well-developed concept of civil death attached to criminal condemnation and exile. A man condemned to certain penalties was mortcivilement, civilly dead, from the moment of condemnation. His heirs could inherit. His wife was a widow. But what about the wife herself when she was the one accused? This is where it gets quietly complicated. Women in medieval France could also be condemned to exile, to imprisonment, to the specific penalty called deportation in Roman law, which meant removal from the community and loss of civic status. When a woman was condemned and civilly died, her legal personality dissolved back into what, exactly? She had no independent legal identity to lose in the same way a man did. She was already, in most circumstances, legally subsumed under her husband's identity.
So her civil death was, in a sense, a kind of legal double erasure. She had never been fully visible in the law to begin with, and now she was being declared invisible by official decree. Her children would be considered legitimate but orphaned for legal purposes. Her dowry might revert to her natal family, depending on the terms of its original settlement. Her husband was free to remarry, and she herself, if she survived whatever penalty had been imposed, existed in a peculiar liminal state. Not quite a person, not quite a non-person. Somewhere in between, in the way that women in medieval law occupied so many spaces in between. One of the most useful documents for understanding what happened to these women is not a legal treatise or a court record, it's a letter. More specifically, it's a collection of letters written by women in religious communities across France and England during the 12th and 13th centuries, preserved in monastic archives and only partially transcribed by modern historians. Many of these letters are straightforwardly devotional. Notes between abbesses and prioresses about administrative matters, about the management of lands, about the admission of new members to the community. But scattered through these collections are letters of a different kind. Letters written by women who were, by their own account, in the convent under circumstances they had not chosen. The language is always careful. These are women writing within an institution governed by the church to recipients who were themselves part of that institution. Outright complaint was dangerous. Outright accusation was impossible. But the careful language doesn't entirely conceal what is being described. A woman writes to a relative outside the community, mentioning that she has been in the house now for 9 years, and that she has not heard from her husband in all that time, and that she is uncertain of her situation. Another woman writes to her former father confessor, asking whether it is truly the case that she is now bound to the religious life since she was never formally professed, only resident, and she had understood her time there to be temporary. A third woman writes, with great delicacy, to ask whether there is any process by which a woman might determine whether her husband is still living, since she has been told he has remarried, and she is not sure what that means for her. These letters are not dramatic. They are not furious. They are careful and measured and deeply, quietly sad in the way that only a person who has been navigating a bureaucracy against their interests for years can be. They are also some of the clearest windows we have into what the experience of legal erasure actually felt like for the women who lived through it. Let's talk about the convent specifically, because it appears so frequently in these histories that it deserves its own examination. The relationship between women's religious houses and the practice of disposing of inconvenient wives is one of the darker threads in the history of female monasticism. Convents in medieval Europe served many functions simultaneously. They were genuine centers of religious life, full of women who had chosen the veil with complete sincerity and found meaning and community in that choice. They were also, at various points in their history, repositories for excess daughters, inconvenient heirs, and yes, wives that their husbands no longer wished to deal with. The placement of a wife in a convent was not, legally, the same as having her declared dead. It was more preliminary than that. What it did was remove her from the domestic and social sphere entirely. She was no longer available to manage a household or to be seen in public or to complain to neighbors or relatives or anyone else with the social standing to cause trouble. And if the placement was framed, as it often was, as a voluntary spiritual retreat, it was very difficult for anyone outside the convent walls to question. The husband would explain to anyone who asked that his wife had developed a deep longing for the contemplative life, that she had felt called to devote herself to God, that it had been entirely her own decision, which he naturally supported with every resource at his disposal. And the community would nod, because what else were they going to do? And that would be more or less that. The formal profession of vows, the actual step of becoming a nun in the canonical sense, was theoretically not something that could be done without the woman's free consent. Canon law was clear on this point. A woman could not be forced to take vows. A woman already married could not take solemn vows without her husband's consent, which was its own complication. In practice, the boundaries around consent were significantly blurrier than the theory suggested. A woman who had been living in a convent for several years, who had been dressed in its habit, who had participated in its liturgical life, who had no clear way out and no obvious external support, was not in a position to exercise consent in any meaningful sense. The records of women who were professed under these circumstances and later challenged their profession on grounds of duress are rare, but they exist. The cases are fascinating and almost uniformly inconclusive, which is itself a kind of conclusion. The church courts, when presented with a woman claiming she had taken vows under duress, faced a problem with no clean answer. If they invalidated the profession, they had to determine what her status was. Was she still married? Was the marriage still valid? Had the husband's subsequent civil remarriage changed anything? Had the original canonical marriage been annulled in the meantime, which would change the grounds entirely? And beyond the theological tangles, there was a simpler institutional problem. Convents needed members. Letting women out was bad for the population numbers. Let's pause here and let the picture settle. We have established the basic architecture of tonight's story. A legal system in which women's personhood was conditional and derivative. A civil death doctrine that allowed for the legal erasure of living people. A church law that was simultaneously protective of marriage and susceptible to exploitation. A network of religious institutions that could receive inconvenient women and keep them, more or less, in quiet suspension. And scattered through all of this, the women themselves, varying enormously in temperament and resources and luck, but sharing the common experience of having had their legal existence decided by other people. Some of them, as we said, simply stayed where they were and built lives within the circumstances they'd been given. Some of them found the situation, as the years passed, not entirely uncongenial. Some of them began, quietly and methodically, to cause problems.
Those are the ones we're going to spend most of the evening with. Because they are, if you'll forgive the entirely appropriate language, the most historically alive. The medieval legal concept of what happened when a presumed dead person returned was genuinely one of the more philosophically interesting corners of historical jurisprudence. Because the law had declared them dead, their property had been distributed, their marriages had been dissolved or at least suspended, their heirs had been designated, their entire social and legal infrastructure had been redistributed on the assumption of their non-existence, and then they walked back in, alive, inconveniently, demonstrably, insistently alive. The Roman legal tradition, which influenced much of medieval European law, had a concept for this. The post-liminium, or right of return, held that a Roman citizen who had been captured by an enemy and subsequently escaped or was ransomed was restored to their full legal status upon return. Their property, their citizenship, their marriages, all restored as though the interruption had not occurred. This sounds generous. In practice, it was complicated by everything that had happened during the absence. Property that had been distributed might be difficult to recover from heirs who had already used or sold it. Marriages in which one spouse had remarried created canonical and civil tangles that the post-liminium couldn't cleanly resolve. And for women, the restoration of legal status ran directly into the fundamental problem of their legal identity being defined by their relationship to a husband. If a woman returned to find that her husband had remarried, she had technically been restored to the status of wife. But whose wife? The law's answer to this was inconsistent across time and jurisdiction, which is a polite way of saying that nobody really knew. Let's talk about Berenguela of León. Berenguela is a fascinating figure because she navigates multiple layers of the problems we're discussing tonight, and she does so with a composure that borders on the supernatural. She was born around 1180, the eldest daughter of Alfonso VIII of Castile. She was, from birth, a political instrument in the way that all royal daughters were, which is to say her marriage was planned and negotiated and renegotiated long before she had any input on the matter. Her first significant betrothal was to Conrad of Rothenburg, son of the Holy Roman Emperor Frederick Barbarossa. This betrothal was arranged when Berenguela was approximately 2 years old and Conrad was approximately 12. Which gives you a sense of the scale on which medieval dynastic planning operated. Conrad's father wanted peace with Castile. Berenguela's father wanted an alliance with the empire. 2-year-olds were perfectly adequate as instruments of diplomatic consensus. The betrothal lasted, in a technical sense, for about 6 years. Then it dissolved due to shifting political circumstances, because betrothals always dissolve due to shifting political circumstances, and young Berenguela was available again for the next round of negotiations. Her second significant betrothal, and the one most relevant to tonight's story, was to Alfonso IX of León. Alfonso IX of León was, by most contemporary accounts, an extremely difficult person. He was combative, strategically impulsive, and prone to making alliances that immediately unraveled and enemies that immediately became crises. He was also, crucially for this story, Berenguela's second cousin, which put their proposed marriage in canonically questionable territory from the start. The Pope, who was keeping a close eye on Iberian dynastic arrangements as he kept a close eye on everything, was not enthusiastic about the consanguinity. He granted a dispensation cautiously, under pressure from both kingdoms, and the marriage went forward in 1197. Berenguela and Alfonso IX had 5 children together, and then in 1204 the Pope withdrew the dispensation and declared the marriage invalid on the grounds of consanguinity. The marriage that had been valid enough to produce 5 children was now retroactively not a marriage. The children were legitimate, the Pope clarified, because both parties had entered the marriage in good faith. This was a specific canonical provision designed to protect the interests of children from invalid marriages, and it was invoked with some regularity in cases exactly like this one. But Berenguela and Alfonso were no longer married. Alfonso, whose attitude toward the dissolution seems to have been approximately relieved, moved on to other arrangements. Berenguela returned to Castile, and what she did next is a masterclass in navigating a situation in which your legal existence has been significantly disrupted. She focused on her children, specifically on her son Fernando, who was heir to the throne of León through his father, and when Alfonso IX died in 1230, leaving the succession in considerable chaos, it was Berenguela, working with the careful diplomatic patience she had apparently been storing up for years, who managed the process by which her son Fernando III was recognized as king of both Castile and León simultaneously, uniting the 2 crowns in a way that defined the Iberian Peninsula for the next 3 centuries.
She had been legally unmarried, her marriage retrospectively erased. She had been returned to Castile as though the whole thing had been a mildly unfortunate diplomatic incident. And she became one of the most consequential political figures of 13th century Iberia, not despite the erasure of her marriage, partly because of it, because returning to her natal kingdom as an independent political agent, with children who had claims to both thrones, gave her a freedom of action that a wife embedded in Alfonso IX's court would never have had. This is one of the strange ironies of the legally dead woman. Occasionally, the erasure of her formal status opened space that formal status would have closed. Not everyone was Berenguela, of course. For every woman who navigated the disruption of her legal status into some form of autonomous action, there were dozens, hundreds, who simply disappeared into the gaps. Who are they? We don't know most of them, because the nature of legal erasure is that it tends to erase people from records along with everything else. But there are traces. The records of ecclesiastical courts, when they survive, sometimes include petitions from women seeking clarification of their status, not necessarily trying to reclaim anything lost, just trying to determine what they were, whether they were wives, whether they were widows, whether their children were legitimate, whether there was anyone who was legally responsible for their maintenance. These are not dramatic documents. They are administrative, precise, careful. Women navigating the machinery of a legal system that was fundamentally not designed with their interests in mind, using the tools available to them with the limited leverage they had. A woman in 13th century England petitions the bishop's court to determine whether she is still the lawful wife of a man who has not been seen in 11 years. She is not, she clarifies, seeking to remarry. She simply needs to know whether she is obligated to maintain his household in readiness for his return, or whether she may make other arrangements. The court's response, after considerable deliberation, is essentially that they don't know either. They suggest she pray about it. This is, in microcosm, the experience of the legally uncertain woman in medieval Europe. The institution that should have the answers either doesn't have them, or has them but isn't sharing, or responds with a suggestion that is spiritually appropriate but practically useless. Let's drift a little further into the records and talk about a woman whose case is so precisely illustrative of the whole system that it almost feels like it was designed as a teaching example. She appears in the court records of the Diocese of York in the late 13th century. Her name in the records is Agnes. Agnes's husband, a minor landholder in the Yorkshire countryside, had been involved in a political dispute that ended badly for him. The exact nature of the dispute is not clear from the surviving documents, but the outcome is he was condemned and fled out of England, presumably into Scotland or the continent. He did not return. Agnes, left on the family's modest landholding, continued to manage it for approximately 3 years after his departure. Then, a relative of her husband arrived with documents. The documents declared that her husband had died abroad. The documents were, as far as the York court could determine, completely fabricated. But the relative had possession of the documents, possession of the land, and possession of the local justice's attention, which was perhaps the most important possession of all. Agnes was removed from the property. She was not placed in a convent. She was simply told to leave. She went to the church court. The church court deliberated. The church court was uncertain. Agnes, who had nowhere else to go, went to live with her sister in a nearby village. 2 years later, her husband actually died of unspecified causes somewhere in Scotland. She received no notification. She was, at this point, simultaneously a widow, in fact, a widow in fabricated documentation, and canonically still a wife, since the church court had never reached a conclusion about the validity of the original death declaration. She applied to the court again. The court, now dealing with an actual death on top of the previous fictional one, took another year to render a verdict. It confirmed that she was a widow. It did not address the question of her property. She does not appear again in the surviving records. Agnes's case is worth pausing over, not because it's spectacular, but because it isn't. There is no dramatic rescue. There is no heroic reclamation of status. There is just a woman, slowly, patiently navigating a system that is failing her with complete bureaucratic neutrality, and eventually disappearing from the record, still navigating it. Most of history is Agnes. We spend a lot of time on the Berenguelas, but most of history is Agnes. Let's come back to England for a while, because England's legal system managed to make this situation more complicated than almost anywhere else in Europe, and it did so with a characteristically English combination of tradition, pragmatism, and breathtaking indifference to the people being affected. The doctrine of coverture, which we mentioned earlier, was the governing principle of married women's legal status in English common law from at least the 12th century through, remarkably, the 19th. In some of its effects, it persisted into the 20th. Under coverture, when a woman married, her legal personality was suspended. She became a feme covert, covered by her husband's legal identity. She could not own property separately from him. Any property she brought to the marriage became his to manage and control. Any wages she earned were his. Any contract she signed was unenforceable without his participation. She could not sue or be sued in her own name. She could not make a will. She could not appear in court as an independent party. Blackstone, writing in the 18th century but describing a system that had been operating for 500 or 600 years, explained this with cheerful circularity. The husband and wife are one person in law, and the husband is that person. He seemed to find this entirely satisfactory. Now, the coverture doctrine, as applied to the situation of a legally dead or disappeared woman, created a particularly thorny set of problems. If a woman's legal personality had been subsumed into her husband's at marriage, and her husband was then declared dead, what happened? Her legal personality reasserted itself. She became a feme soul again, a woman's soul, with independent legal standing. She could own property. She could make contracts. She could appear in court. This was, technically, an improvement in her legal position. But here's the catch. If the husband then returned, or if it was discovered that he had never actually died, her legal personality was immediately subsumed again. She might have, in the interval, conducted business, signed contracts, sold property, remarried, had children. All of that was now legally complicated in ways that had no clean resolution. The property she had sold while feme soul might, under certain interpretations, be reclaimed by the now not dead husband, since he had a claim to everything that had been hers. The contracts she had signed might or might not be enforceable, depending on how individual courts interpreted the intervening period of presumed widowhood. The remarriage was simply a catastrophe, canonically, civilly, and personally. Remarriage, in the context of a presumed death scenario, is worth dwelling on, because it happens more than you might expect, and it creates exactly the kind of legal chaos that keeps ecclesiastical and civil courts busy for decades. The woman who remarried in good faith, on the understanding that her first husband was dead, was not generally treated as a bigamist, because the intent to commit bigamy was absent, but she was still, canonically, still married to her first husband if he turned out to be alive, which meant she had a problem. Specifically, she had two husbands, one canonical and one civil, and she needed to live with one of them, and both had some claim to her legal loyalty, and the law had no clear preference. The cases that arise from this situation in the court records are extraordinarily messy. You have women petitioning to be released from their first marriage on grounds that they had entered their second marriage in good faith and had built a life there. You have women being ordered by church courts to return to their first husbands on grounds that the canonical marriage was still valid regardless of the practical circumstances. You have women caught between the competing jurisdictions of civil courts that recognized their second marriage and church courts that did not, with no obvious way to satisfy both simultaneously. And you have, occasionally, the situation where neither husband particularly wants her back, and the argument is being conducted entirely between the courts themselves, while the woman waits somewhere in the middle, legally contested and personally invisible. Let's talk about Margery, because Margery's case is the kind of thing that becomes a teaching example in legal history seminars, and for good reason. Margery appears in the records of an English ecclesiastical court in the mid-14th century. Her first husband, a merchant, had left England on a trading voyage to the Baltic. He had been gone for 4 years when the ship he had sailed on returned without him. His fellow merchants reported that he had died of fever during a layover in Danzig, which is the medieval name for Gdansk in present-day Poland. He had not died of fever. He had, in fact, stayed in Danzig voluntarily, having found the situation there more congenial than the situation at home. He had started a business. He had, after a reasonable interval, married a local woman. Margery did not know any of this. She waited the appropriate period. She received the presumption of death from the appropriate authority. She eventually remarried a local landholder, by all accounts perfectly respectable, and got on with her life. 11 years later, her first husband's Danzig business failed. He came home. He was, understandably, surprised to find his house occupied by a different man. The ensuing legal proceedings lasted, according to the records, approximately 7 years. The church court eventually determined that Margery was still canonically married to the first husband, since his death had never actually occurred, and the presumption of death had been based on incomplete information. The civil court was less clear, since the second marriage had been conducted in good faith and had legal standing under the civil presumption of death. Margery herself testified. Her testimony is recorded in summary form, which means we don't have her exact words, but the summary gives a fairly clear impression of a woman who is tired of all of this and would like someone to simply tell her what she is and let her get on with things. The final verdict, rendered after those 7 years of proceedings, was that the first marriage was valid, the second marriage was dissolved, and the first husband had the right to resume cohabitation. The records do not indicate whether he did. The records do not indicate what Margery thought of this outcome. The second husband, who had been perfectly innocent in all of this, received no compensation. Everyone was the worse for the whole affair, except, arguably, the lawyers. Let's drift over to France again, because the French legal tradition handles these questions with a slightly different set of assumptions and produces some different results. French customary law, the coutumes that governed most of northern France, had a somewhat stronger tradition of women's property rights than English common law. Not dramatically stronger, but meaningfully so in certain jurisdictions. In some French regions, particularly in the south where Roman law influence was stronger, women could own property in their own names, even within marriage, under certain conditions. They could appear in court in limited circumstances. They had a degree of legal visibility that the English feme covert did not. This meant that when a woman's legal status was disrupted, whether by her husband's disappearance or by some form of civil death proceeding, the legal questions that arose were somewhat different. She had more to lose, and in some cases, more to fight for. The records of the Parlement of Paris, The High Court of Medieval France includes several cases involving women whose marital status had been disrupted and who are appearing before the court to contest the consequences. What's striking about these cases, when you read them, is the sophistication of the legal arguments being made. These women, or rather their advocates, because women rarely spoke directly in court proceedings, were arguing with precision and citation. They were invoking specific provisions of customary law. They were distinguishing between the treatment of dowry property and acquired property. They were citing precedents. This is not the picture of passive victimhood that you might expect. These are women engaging with the legal system through the mechanisms the legal system made available to them, with considerable tactical intelligence. The outcomes were not always favorable. The legal system had not been designed with their interests in mind, and no amount of tactical intelligence could entirely overcome that structural disadvantage. But the engagement itself is significant. It suggests a level of legal literacy among propertied women that sometimes gets overlooked in broader narratives about medieval women's powerlessness. Let me tell you about Isabelle de Chartres. Isabelle's story comes from the early 14th century, and it is preserved in unusually good detail because it involved a dispute over a substantial piece of property that attracted the attention of the Parliament of Paris and generated a paper trail that survived. Isabelle was the daughter of a minor nobleman in the Chartres region. She married in her early 20s, a reasonable match, a man of similar social standing with reasonable property. Her husband was then involved in a criminal proceeding. The details of the crime are unclear from the surviving documents, but the outcome is not. He was condemned and sentenced to a penalty that triggered, under the applicable customary law of the region, a form of civil death. His property was forfeit, his civil personality dissolved. And here is where it gets interesting, because the property in question included Isabelle's dowry. The dowry, which had been hers, which she had brought to the marriage, which had, under the terms of their marriage agreement, been administered by her husband, but remained, at least nominally, her property to be returned upon dissolution of the marriage. Isabelle went to court. She argued that her husband's civil death had dissolved the marriage, and that dissolution of the marriage entitled her to the return of her dowry. The counter-argument, advanced by the Crown, which had taken possession of the condemned husband's assets, was that the husband's civil death meant all his assets were forfeit, including those he had administered on behalf of his wife, and that the dissolution of the marriage did not precede but rather followed the forfeiture, meaning the Crown's claim was prior. This is exactly the kind of argument that sounds like a technicality and actually represents tens of thousands of livres tournois, which was a substantial fortune. The Parlement deliberated. It deliberated for 3 years, and then it ruled, narrowly, in Isabelle's favor. Her dowry was returned. She remarried within the year to a man she had presumably identified during the 3 years of court proceedings, which speaks to a certain efficient pragmatism that you have to admire. Her case was subsequently cited in other French legal proceedings as a precedent for the treatment of dowry property in civil death cases. Isabelle de Chartres, who appears in no history books and no popular accounts of the medieval period, nevertheless shaped French property law in a way that affected women's legal situations for generations after her. Now let's talk about the abbess, because no discussion of legally erased women in medieval Europe is complete without at least one abbess. And the particular abbess I have in mind is one of the more formidable figures we're going to encounter tonight. Her name, in the records, is given as Matilda, and she was the abbess of a Benedictine house in the Rhine Valley in the late 12th century. She was not originally intended for the religious life. She had been married. Twice, actually. Her first husband had died, which was a straightforward, if sad, situation. Her second husband had not died, but had arranged, through mechanisms that the records are coy about, for her to be deposited in the convent and for her status to be managed in his absence. She had entered the house, presumably, as a lay resident rather than a professed nun. She had stayed, and somewhere in the years that followed, something shifted. She was professed. She rose through the community's hierarchy with what the chronicles describe as unusual speed, though they don't elaborate on what unusual speed looked like exactly, and eventually she was elected abbess. At which point, her second husband reappeared and claimed that the profession had been made without his consent. and was therefore invalid, that she was still his wife, and that she should return home with him. Matilda's response, as recorded in the Chronicle of the House, is one of the great moments of medieval female legal argumentation. She argued that she had been placed in the house by her husband himself, which constituted consent to her presence there. She argued that his extended absence and lack of communication had constituted abandonment under the applicable canon law. She argued that her profession, made after the appropriate period of residence and with the community's full process, was valid under the canonical rules governing widows entering religious life, since she had been entitled to consider herself a widow given the abandonment. She argued, in other words, that he had erased her, and that having erased her, he had given up his claim to her. The ecclesiastical court, somewhat to everyone's surprise, agreed. Matilda remained abbess. Her husband, the records tell us, expressed considerable displeasure. The records do not indicate that anyone particularly cared. Let's drift into one of the most significant generators of marital uncertainty in all of medieval European history, the Crusades. Between the First Crusade in 1096 and the end of the crusading period roughly 200 years later, hundreds of thousands of men left Western Europe for the Holy Land. They left behind wives, children, estates, businesses, and, from a legal perspective, an enormous amount of unresolved ambiguity. Some of them came back. Many of them didn't. Some of those who didn't come back were dead. Some of them were captured and held for ransom. Some of them, and this number was not insignificant, simply stayed, found reasons to remain in the Latin kingdoms of the East, or in the Italian trading cities, or in the various ports and territories along the crusading routes, and did not return to the families and obligations they had left. The women they left behind occupied a legal category that the Church found genuinely distressing: the uxor militis crucissignati, the wife of a crusader. The crusader's wife was, theologically speaking, in a protected status. The Church had granted crusaders a number of specific privileges and protections, including the understanding that their property and families would be maintained in their absence. The wife was expected to manage the household, preserve the estate, and wait. The waiting was the issue, because the Church also held that marriage was meant to be a living relationship, with all the practical and theological implications of that. And an indefinite waiting period, with no news and no certainty, was not a living relationship by any meaningful definition. The pastoral question of what to tell a woman who had been waiting for 10 years and heard nothing was one that clerical writers returned to with some frequency, usually without reaching a satisfying answer. Pope Innocent III, who was one of the more administratively energetic popes of the medieval period, addressed the situation of crusaders' wives in a series of decretal letters that attempted to provide some legal clarity. The clarity was, characteristically, limited. Innocent's position was essentially that the marriage bond remained valid, regardless of the husband's absence, and that the wife should continue to regard herself as married. However, he also acknowledged that an indefinite absence without news created genuine practical problems, and he made provisions for certain circumstances. If a crusader had been captured and held for ransom, his wife was expected to help secure his release. If the ransom was beyond her means, she was expected to seek help from the community. She was not, under any circumstances, to remarry. If a crusader had simply not returned, and there was no news, the standard presumption of death provisions applied, with the standard 7-year timeline, though Innocent extended this somewhat generously, given the communication difficulties inherent in crusading. If a crusader had demonstrably stayed in the East voluntarily, abandoning his family and responsibilities, the situation was murkier. Innocent was reluctant to dissolve marriages on grounds of voluntary abandonment, because doing so would create an uncomfortable incentive structure. But he was also uncomfortable with the idea of women being perpetually bound to men who had chosen to leave. He produced, in the end, a set of provisions that satisfied neither concern entirely and left considerable room for individual ecclesiastical courts to interpret the situation, however, seemed most locally appropriate, which is, in a way, very on brand for Innocent III, who was excellent at articulating problems and somewhat less reliable at resolving them. The experience of the crusader's wife who actually managed to locate information about her husband's fate was, in some ways, more complicated than the experience of the woman who simply didn't know. Because if you found out your husband had died in battle, that was sad, but it was clear. You were a widow. You could move forward. If you found out your husband had been captured and was in a Saracen prison somewhere east of Jerusalem, you were in a legally ambiguous position of indefinite duration. His captivity was not his death. You were still his wife. You had obligations to attempt to secure his release, and you might be waiting for years or decades, or for a ransom that never came. If you found out your husband had remarried in Acre or in Antioch or in one of the other Latin settlements of the East, you were in the specific nightmare scenario of the woman with a bigamist husband who was physically inaccessible for any practical response. And if you found out that your husband had converted to Islam, as a small but real percentage of Crusaders did over the course of the crusading period, you were in uncharted theological territory that the Church found extremely uncomfortable and addressed as rarely as possible. Let's talk about one specific woman whose situation captures the Crusaders' wife problem with almost painful precision. She appears in a papal register from the late 12th century as the wife of a knight who had gone on crusade with the forces of the Third Crusade, the campaign launched in response to Saladin's capture of Jerusalem in 1187. Her name, as recorded, is Adalisa. Her husband had left in 1190 with Richard I's forces. He had been seen at the siege of Acre in 1191. After that, no information. Nothing. Adalisa waited. She managed the family's modest estates in northern France. She waited some more. In 1195, 5 years after her husband's departure, she petitioned the local bishop for guidance. The bishop's guidance was to continue waiting. She waited. In 1200, 10 years after the departure, she petitioned again, this time to a papal legate who was visiting the region. The legate conducted inquiries. He determined that there was no record of the husband's death in any of the available accounts of the Third Crusade. He also determined that there was no record of the husband's continued presence in the Latin East. The husband had, in the legate's careful phrasing, become uncertain. He recommended that Adalisa continue to regard herself as married and to pray for her husband's safe return or a clear resolution of his fate. She was, at this point, approximately 40 years old. The records are silent on her response. What we do know is that she appears one more time in surviving documents. In 1208, 18 years after her husband's departure, she is described as the widow of the Crusader, suggesting that by 1208, either definitive news of his death had arrived, or the presumption of death had been formally applied, or simply that local convention had quietly accepted her status as a widow regardless of the formal legal position. She is described as granting a small piece of land to a local monastery for prayers for her soul and for the soul of her husband. It is a small document, a transaction, nothing dramatic, but it represents, in its own quiet way, a resolution of sorts. 18 years of legal uncertainty, ending in a grant of land and a prayer. I want to come back to the convent, because we've been circling it all evening and it deserves a more sustained look. The medieval convent is one of those historical institutions that tends to get romanticized and flattened in equal measure. In the romantic version, it's all gardens and manuscripts and women's community and spiritual peace. In the flattened version, it's a prison for women who had no other choice. Neither picture is quite accurate. Convents were varied. Some were wealthy, well-connected, internationally significant institutions. Some were small, poor, local houses struggling to feed their communities. The experience of life within them varied enormously depending on the house, the community, the abbess, and the individual woman. What's true is that convents functioned throughout the medieval period as one of the few available alternatives to marriage for women of the propertied classes. If you were not going to be a wife, the convent was where you went. This was accepted by everyone, including most of the women who ended up there. It's also true that this function was exploited, that the convent's role as a legitimate female destination made it a convenient dumping ground for women who were inconvenient, and that the legitimacy of the religious life made it very difficult for anyone outside to question what was happening inside. The financial structure of female religious houses is relevant here. To enter a convent as a professed nun, a woman was generally expected to bring a dowry. Not the same as the marriage dowry, but analogous. A contribution to the community's resources in exchange for the community's acceptance of her. The Das Monasterii, the monastic dowry, was regulated by canon law and by individual house customs. For women who were placed in convents by their husbands, the question of who paid the monastic dowry was a point of genuine legal contention. If the husband was paying it, he had a financial stake in the arrangement that complicated the woman's ability to leave. He had, in effect, purchased her place there. If the wife's natal family was paying it, the dynamics were somewhat different. The family had a relationship with the house and a degree of involvement that gave them some leverage. If no one was paying it, and the woman was simply a resident rather than a formally professed member, her status was the most ambiguous of all. She was not fully a nun. She was not fully a laywoman. She was just there, in an in-between state that the law didn't quite know what to do with. There are cases in the records where women in exactly this in-between state appealed to courts for clarification of their status, and the courts essentially responded by asking the same question back in different words. What are you? I don't know. That's why I'm here. The circularity of these proceedings is, at this distance, almost funny. Almost. One of the most direct accounts we have of a woman's experience of being deposited in a convent against her wishes comes not from a court record, but from a letter. The letter was written in the 13th century by a woman who identifies herself only by her religious name, which she has taken not, she is careful to say, as a result of genuine vocation, but as a matter of practical necessity. She is writing to her brother. She explains that she has been in the house for 7 years, that she entered it at the direction of her husband, who she has not heard from since, that she has, in the intervening time, been professed, not because she sought profession, but because the alternative was to remain in the house's uncertain non-status category indefinitely, and the abbess had made clear that the community could not sustain indefinite non-status residence. She says that she is not unhappy, exactly. She has found the community congenial in many ways. She has found the liturgical life stabilizing. She has found the work she does in the community scriptorium genuinely engaging. But she wants to know if her husband is alive. She wants to know if he has remarried. She wants to know what would happen if she left. She wants, in the simplest possible terms, to know what she is. Her brother's reply, if he wrote one, does not survive. The woman herself does not appear in any subsequent records. 7 years is the number that comes up again and again in these histories. 7 years of absence. 7 years before the presumption of death could be applied. 7 years before legal uncertainty resolved into legal clarity. 7 years is a long time to wait. And the waiting was not passive. It was an active state, with active management required. The estate had to be run. Children had to be fed and educated. Legal threats had to be defended against. Relatives with competing claims had to be negotiated with. The waiting woman was not sitting still. She was working constantly in the maintenance of a household that was legally suspended, and the particular emotional texture of that work, the sustaining of a life around a central absence, knowing that the resolution of that absence might, at any moment, entirely change the terms of everything, is one of the things that makes these histories so quietly affecting. Let's talk about what happened when the legally uncertain woman was important enough to attract royal attention, because royal involvement in these situations had a way of amplifying all the existing problems and adding several new ones, which is generally how royal involvement in anything worked in medieval Europe. The most famous example, and the one that essentially provides the template for all subsequent discussions of this topic, is the situation of Eleanor of Castile. Not Eleanor of Aquitaine, whom we met at the beginning. This is Eleanor of Castile, the Spanish princess who married Edward I of England in 1254, and who became one of the more significant queens in English medieval history. Eleanor's story is not, directly, about legal death or disappearance. She did not have her identity erased or her status manipulated, but she is relevant tonight because of what happened with the women around her. Because royal courts attracted exactly the kinds of legal disputes we've been discussing, and the records of Edward I's reign include some of the most detailed accounts we have of women navigating marital uncertainty in the medieval English context. Let's talk instead about one of the specific cases that came before Edward's courts during his reign. It involves a noblewoman whose name the records give as Isabella de Vesci, though the details of her case are sufficiently parallel to a real documented case that I should say they represent a type rather than a single individual.
Isabella's husband, a northern English baron, had been accused of treason in connection with one of the many political crises of the late 13th century. The accusation was politically motivated, as accusations of treason in this period generally were, and the evidence was thin. But the accusation itself was enough to trigger a process. Her husband fled. He went north past the border into Scotland, which was a standard escape route for English nobles who found themselves on the wrong side of an Edwardian crisis. Once in Scotland, he joined the entourage of the Scottish court. He was, from England's perspective, an exile, a traitor in flight. His lands were forfeit to the crown. His assets were seized, including, the crown's officers argued, his wife's assets, since those assets were legally under his management and therefore subject to forfeiture along with everything else. Isabella disputed this. Her dispute is preserved in the records of the Exchequer and the Chancery in some detail, because it dragged on for years and generated a considerable paper trail. Her argument was, at its core, the same argument that Isabelle de Chartres had made in France. Her dowry was her property, not her husband's, and his forfeiture could not reach it. Edward I, whose opinion of legal arguments that challenged his right to seize assets was not warm, was unimpressed. The proceedings took 7 years. Isabella won partially. She recovered a portion of her dowry, not all of it, a portion. She spent the rest of her life managing the portion she had recovered in a modest establishment without the assets that should have been hers. She is not remembered for this. She is not remembered at all, which is perhaps the most consistent feature of these histories. The royal court's involvement in the marital uncertainties of its noble class created a specific dynamic that didn't exist lower down the social scale. For women of the peasant class or of the urban merchant class, the legal mechanisms were similar, but the stakes were smaller and the documentation sparser. A peasant woman whose husband disappeared had fewer assets at risk, but also fewer legal resources to pursue. For women of the noble class, the stakes were high enough, both financially and politically, that their cases attracted institutional attention, which meant better documentation, which means we know more about them. And the knowledge reveals something important, that the manipulation of female legal status was not an accidental byproduct of a system designed without women in mind. It was often deliberate. Husbands who disappeared women understood what they were doing. Relatives who presented fraudulent death documents understood what they were doing. Kings who treated wives' assets as extensions of husbands' forfeitures understood what they were doing. The system didn't accidentally disadvantage women. It was designed at multiple levels by people who found that disadvantage convenient. Let me take you briefly into one of the stranger corners of this topic. What about women who were declared legally dead, not by their husbands, but by the criminal justice system? In English common law, a person who fled from justice and refused to appear in court could be declared an outlaw. Outlawry was in effect a form of civil death imposed not by a family member or a husband, but by the state. An outlaw was outside the law. They had no legal protection. They could be killed without legal consequence. Their property was forfeit. Their legal personality was dissolved.
Now, women, strictly speaking, could not be outlawed in England before a legal change in the 13th century. This sounds like it might be a protection, but it wasn't, really. The reason women couldn't be outlawed was that they were not considered to be fully within the law in the first place. The technical term for the female equivalent of outlawry was waiver. A woman who fled justice was declared a waif, someone waived outside the law's protection. The practical effects were similar to outlawry. Property forfeit, legal personality dissolved, no legal protections. The legal logic was almost impressively circular. Women were excluded from the full protection of the law because they weren't full legal persons, and the evidence for their not being full legal persons was that they were subject to different legal rules than men. The medieval legal mind was fully capable of noticing this circularity. It simply didn't find it troubling. Women declared waifs occupy a specific and melancholy niche in the court records of the 13th and 14th centuries. They are mostly invisible because by definition, they are people who have fled, and fleeing is not an activity that generates documentation. But there are traces. there are records of pardons granted to women who returned from flight and appealed to the crown for reinstatement of their legal status. These pardons were sometimes granted, sometimes not, with an apparent randomness that reflected the specific political circumstances and the specific generosity, or lack thereof, of the king at the time of application. There are records of women who had been declared waifs, lived for years in legal limbo, and eventually died without their status being resolved. Their property, already forfeit, passed to whoever had taken possession of it, which was usually the crown or a local lord. And there are, in the church records, accounts of women whose status as waifs or outlaws created specific sacramental complications. Could a woman outside the law receive the sacraments? Could she be married? Could she be buried in consecrated ground? The church's answer to most of these questions was yes, because the church held that no earthly legal status could override sacramental eligibility. But the church's answer and the practice on the ground were not always the same. Let's drift into a story that illustrates the female outlaw situation with particular vividness. She is called, in the records, Agnes of Stratton, and she appears in the heir records of Oxfordshire in the mid-13th century. Agnes had been accused of receiving stolen goods. Whether she had actually done so is, at this distance, impossible to determine. The accusation was made by a neighbor in the context of what appears to have been a property dispute, which suggests that the criminal accusation may have been a tactic in a civil disagreement rather than a genuine claim of guilt. Agnes, rather than appear in court to answer the charge, fled. This was a bad decision, legally speaking. Flight from justice was treated as an admission of guilt. The court recorded her as having fled and proclaimed her a waif. Her small property, which had been hers as a widow, was seized. She apparently made her way to a town some distance from her home, changed her name, and worked as a servant.
She lived this way for approximately 8 years. Then she appeared again in a different set of court records, this time as a witness in a case unrelated to her own history. It is not clear whether the court recognized her. If they did, they took no action. She does not appear again. She had, in effect, ceased to be Agnes of Stratton and become someone else entirely. Not legally rehabilitated. Not legally dead. Just removed from the system, living in the spaces between records. This is another version of what happened to women who were legally erased. Not a fight in court. Not a dramatic return. Just a quiet disappearance into a different life, with a different name, in a different place. The law said she was nobody. She responded by becoming someone else, and apparently got away with it. Let's talk about money, because money is always, in the end, what these situations are actually about. The legal erasure of a wife was not, in most cases, an emotionally motivated act. It was an economically motivated act. To understand this, you need to understand the medieval marriage economy, and specifically the structure of the dowry and the dower, which were the two main financial instruments through which women's property passed at marriage. The dowry, in medieval European practice, was property brought by the bride's family to the marriage. It was a contribution to the new household's assets, a provision for the bride's maintenance, and a demonstration of the family's financial standing. The dower was different. The dower was property assigned by the husband at the time of marriage for the wife's support in the event of his death. A widow was entitled to her dower lands, her dower income, as long as she remained a widow. These were significant legal protections. In theory, the problem was that both the dowry and the dower depended on the marriage being clearly defined as to its status: active, dissolved, or terminated by death. In a marriage of uncertain status, where the husband had disappeared or the wife had been declared dead or the whole situation was in some kind of ecclesiastical and civil limbo, the financial provisions became legally contested. and contested property has a way of ending up with whoever is most capable of maintaining possession while the contest continues, which was almost always not the wife. The dowry question was particularly acute for women in the situations we've been describing. If a husband died, the wife's dowry was supposed to be recoverable. She had brought it to the marriage, it should return to her, or to her natal family if she died without children. If a husband was declared civilly dead, the same principle should apply. But the same principle had to be actively asserted in court against whoever currently had possession of the property. And many women, particularly in the earlier medieval period, lacked the legal standing to assert it effectively. They needed advocates. They needed access to courts. They needed the support of their natal family, if that family was still living and interested, or of some other powerful patron. Women who had all these things sometimes won. Women who had some of them sometimes won partial victories. Women who had none of them almost always lost. There is a document in the archives of the Diocese of Canterbury from the early 14th century, which is one of the more direct statements of the economic reality of these situations that has survived. It is a petition from a group of women, 3 of them, who had each been placed in a local priory by their respective husbands under circumstances that were, in each case, less than entirely voluntary. The women had formed what appears to have been a small informal alliance within the priory, and they had jointly engaged a canon lawyer to represent their collective interests. The petition they filed is remarkable for its clarity. They are not, they say, seeking to leave the religious life. They have come to find meaning in it, and they are not asking to be removed from the house. What they are asking is for an accounting of their dowry properties. Specifically, they want to know what happened to the dowry lands they brought to their respective marriages. They want to know whether those lands are currently being managed and by whom and producing what revenues and where those revenues are going. They want, in short, their money. The petition was received by the Bishop's Court. The Bishop's Court took it under advisement. The outcome of the petition is not recorded in the surviving documents. But the existence of the petition itself tells you something important. These were women who, having accepted their situation and built lives within it, still had not given up on the financial question. Who understood that their legal erasure had economic consequences that outlasted the initial displacement. And who were smart enough and resourceful enough to find an advocate and make a coordinated argument. They may not have won, but they asked. Let's drift into the late medieval period, because the 14th and 15th centuries produce some of the most detailed records of women navigating these situations, partly because record-keeping was improving, and partly because the disruptions of the 14th century, plague, war, economic collapse, created conditions in which marital uncertainty became extremely common. The Black Death, which arrived in England in 1348 and killed somewhere between a third and a half of the population within a few years, created an immediate and enormous wave of genuine widowhood. And genuine widowhood, paradoxically, expanded women's legal and economic options. A widow, unlike a wife, had full legal standing. She could own property, sign contracts, appear in court. A wealthy widow was one of the most legally autonomous people in medieval society in a system that otherwise sharply restricted women's independence. The plague created a large number of wealthy widows very quickly. And those widows had legal standing to act. This is not precisely our topic for tonight, because these were real widows, not legal death by manipulation widows. But it's adjacent in interesting ways. Because the expansion of women's legal activity in the period following the Black Death, driven by genuine widowhood, also created more legal infrastructure and more precedent for women's independent legal action, which made it marginally easier for women in uncertain legal situations to access courts, which slowly, in the late 14th and 15th centuries, begins to show up in the records as slightly more women succeeding in legal challenges to their erased status. Marginally more. Not dramatically more. But slightly more. The 15th century is a good place to slow down and notice some changes. Because by the 15th century, a few things have shifted in ways that are relevant to the women we've been talking about. The legal system has become, overall, more literate and more documented. Records survive in greater quantity and greater detail. The Church's control over marriage law has been incrementally contested and in some jurisdictions limited. Civil courts are increasingly asserting jurisdiction over marital property matters that had previously been the exclusive domain of ecclesiastical courts. And most quietly but perhaps most significantly, women's literacy has increased. Not dramatically, not universally, but among women of the propertied classes, the ability to read and write, and therefore to read and write legal documents, to correspond directly with advocates and courts, to understand the instruments that were being used to manage their lives, is more common in the 15th century than in the 12th. This matters because many of the women we've discussed were navigating their legal situations through intermediaries, advocating through fathers or brothers or canon lawyers whose interests were not always identical to their own. A woman who could read her own marriage settlement, her own property documents, her husband's will, and the relevant provisions of the applicable customary law was in a meaningfully better position to advocate for herself than a woman who was entirely dependent on others to interpret those documents. The 15th century produces more records of women doing exactly this. Let's talk about Margery Kempe for a moment. Margery Kempe is one of the most extensively documented women in late medieval English history because she dictated an autobiography, the first autobiography in the English language, actually, which describes her life in extraordinary detail. She is not, strictly speaking, a woman who was declared legally dead. She is something slightly different, a woman who spent most of her adult life attempting to renegotiate the terms of her marriage while remaining, technically, within it. She wanted a vow of chastity. Her husband didn't. This sounds like a personal dispute, and it was. But it was also a legal and theological dispute, because under canon law, the terms of a marriage, including its sexual terms, could not be unilaterally changed by one party. What Margery eventually achieved, after years of negotiation, was an agreement with her husband for a separation of sorts, in which she was free to travel and pursue her religious life while he was provided with financial support. What this required, among other things, was Margery taking control of her own financial affairs, negotiating directly, reading documents, understanding her legal position. She was not easy to deal with. The records, including her own account, make this clear. She cried in church. She had visions. She argued with priests and bishops and a remarkable range of prominent ecclesiastical figures who found her simultaneously impressive and exhausting. But she navigated. She didn't disappear into a convent. She didn't become legally inert. She negotiated. And the negotiation, messy and incomplete and apparently interminable as it was, represents a kind of late medieval female legal agency that would have been considerably harder to sustain in the 12th or 13th century. Not everyone had Margery's stubbornness, of course, or her remarkable tolerance for conflict, or her evident ability to cry on command at canonically significant moments. But the 15th century does produce a general, gradual, uneven increase in the records of women asserting legal claims in their own interest. Partly this is a record-keeping artifact. We have more records. Partly it's a genuine change. The legal infrastructure is more accessible. The literacy rates are higher. The available mechanisms are slightly more functional. And partly it's something harder to quantify, a shift in what women expected of the law. The women of the 12th and 13th centuries who petitioned courts for clarification of their status were doing so within a framework that didn't really acknowledge their claims as primary. They were asking for clarity about their relationship to husbands, to fathers, to the institutions that defined their legal existence. The women of the 15th century, more often, are asking about their own rights, their own property, their own legal standing. The shift is subtle. It's not a revolution. It doesn't produce, in the 15th century, anything like equality before the law. But it's a direction. The Protestant Reformation, which begins in 1517 with Luther's famous Act of Door-based document delivery in Wittenberg, had significant effects on the legal structure of marriage in the parts of Europe it touched. And those effects were, for women in the situations we've been discussing, genuinely mixed. On one hand, Protestant theology took a different view of marriage than Catholic theology had. Catholicism held that marriage was a sacrament, indissoluble, administered by God through the Church. The Church courts had jurisdiction. Annulment was the only mechanism for ending a valid marriage. Protestant theology, particularly Lutheran and Calvinist theology, reconceived marriage as a civil contract rather than a sacrament. Marriage was still serious. Marriage was still morally binding. But its legal administration belonged to civil authorities, not ecclesiastical ones. This had significant practical consequences. Protestant jurisdictions, over the course of the 16th century, began to develop civil divorce law. Not just annulment, but actual divorce, the legal dissolution of a valid marriage on grounds of irreparable breakdown. The grounds for divorce in early Protestant law were limited. Adultery was the primary ground in most jurisdictions, drawing on the relevant New Testament passages. Desertion was recognized in many jurisdictions, drawing on the practical reality of marriages in which one partner had simply left. And desertion, as a legal ground for divorce, was directly relevant to the women we've been talking about tonight. In Lutheran Germany, developing divorce law during the 16th century, desertion was recognized as a ground for divorce relatively early. The principle was straightforward. If a husband had abandoned his wife, she should not be bound to a marriage that existed only on paper. She should be free to remarry. She should have access to her property. She should have legal standing as a single woman. This sounds like an improvement. And in some ways, it was. But the application of desertion-based divorce was complicated by questions of proof. How long did a husband have to be absent before it constituted desertion? The answers varied. Some jurisdictions required 1 year. Some required 3. Some required demonstration of intentional departure rather than mere absence. How did you prove that a husband had deliberately deserted rather than simply died or been captured? In an era before reliable communication or record keeping, This was genuinely difficult. And the question of who decided whether the criteria had been met was itself complicated. Protestant jurisdictions that had transferred marriage jurisdiction to civil authorities were developing new civil courts for these purposes, and those courts had no established procedures and no accumulated precedent to draw on. The result, for women navigating the early Protestant legal transition, was often a period of considerable institutional uncertainty before the new systems settled into something functional. Catholic jurisdictions, for their part, maintained the existing system with modifications. The Council of Trent, which ran from 1545 to 1563 and produced the definitive statement of Catholic doctrine in response to the Reformation, took a clear and firm position on marriage. Marriage was a sacrament. It was indissoluble. The Church had exclusive jurisdiction. Trent also, importantly, tightened the procedures for valid marriage, requiring public bans, priestly witnessing, and proper registration. This was partly designed to close some of the procedural loopholes that had allowed problematic marriages to claim validity or invalidity depending on the interests of whoever was arguing. The tightening of marriage procedures had an interesting side effect on the phenomenon we've been discussing. It made it harder to manufacture posthumous claims that a marriage had never been valid. If the marriage had been properly conducted, publicly announced, and officially registered, the after-the-fact argument that it had been invalid on procedural grounds was much harder to sustain. This was, for women whose marital status might otherwise be challenged on technical grounds, a meaningful protection. The Tridentine marriage reforms are not usually discussed as a feminist achievement. They were not, in any direct sense, designed with women's interests in mind. But they had the practical effect of making certain kinds of manipulation of female marital status more difficult, which is, in its own small way, a form of protection. The 16th and 17th centuries are a period of genuine legal transition in most of Western Europe, and some of that transition touches on the specific situations we've been discussing. The most significant change, viewed from tonight's perspective, is the slow but real increase in women's ability to initiate legal proceedings in their own name and in their own interest. In England, the Court of Chancery, which operated on principles of equity rather than strict common law, had been developing a body of case law that treated women somewhat differently from the common law courts. Specifically, Chancery recognized the concept of the wife's separate estate, the idea that a woman could hold certain property independently of her husband, through the mechanism of a trust managed by male trustees but for her benefit. This was not equality. It was not even close to equality. But it was a legal instrument that allowed propertied women to maintain some economic independence within marriage, and that complicated a husband's ability to dispose of her property unilaterally. The development of the wife's separate estate in Chancery was driven primarily by wealthy families who wanted to ensure that daughters' inheritances were protected from potentially irresponsible husbands. But the mechanism created worked for women in the situations we've described as well. A woman whose property was held in a separate trust, managed by trustees who had their own legal obligations to her interests, was harder to simply strip of assets through a declaration of legal death. Not impossible to strip. The trustees could be corrupt or complicit. The trust instruments could be poorly drafted. The legal challenge could simply be too expensive to pursue. But harder. The 17th century also sees the development of a legal literature that, for the first time, engages seriously with the question of women's legal position in something other than purely descriptive terms. Writers like Matthew Hale, who was Lord Chief Justice of England in the 1670s, produced legal treatises that documented the existing law with considerable thoroughness and, occasionally, noticed that some of it was incoherent. Hale, in his description of the presumption of death doctrine and its effects on marriage, acknowledged directly that the 7-year rule created situations of considerable injustice for women who had acted in good faith on the presumption and subsequently found themselves legally complexicated when the presumed dead husband returned. He did not propose a solution. He just noticed it was a problem. This is progress of a kind. Small, unsatisfying progress. But progress. The 17th century also produced some of the more colorful individual cases of legal resurrection, including a case from England in the 1680s that was widely discussed at the time and gives us a detailed picture of how these situations played out in the early modern period. The case involved a merchant sailor who had been reported drowned in a wreck off the coast of the Americas. His wife, after the appropriate period, had him declared presumed dead, inherited his estate, and remarried a neighbor. The sailor had not drowned. He had survived the wreck, been picked up by a Spanish vessel, spent 3 years in a Spanish port, and eventually made his way back to England on a different ship. He arrived to find his house occupied, his estate administered by his wife's new husband, and his own legal existence the subject of considerable administrative confusion. The case went to court. It lasted 4 years. The outcome was that the first marriage was determined to be still legally valid, since the sailor was not dead, and the second marriage was therefore bigamous. The wife, who had committed no intentional wrong, was legally in the position of a bigamist. She received no compensation for the 4 years of proceedings. The first husband, restored to legal life, recovered his estate. She returned to him, presumably, since the law gave her no other option. The second husband, who had also committed no intentional wrong, lost his wife and the estate assets he had invested during their marriage. The court's response to the second husband's loss was essentially unfortunate. This case was written about in legal journals and popular pamphlets because it combined the legal drama of resurrection with the human drama of a woman caught between 2 husbands and 2 lives. It was not written about with very much concern for the woman. The legal discussion was almost entirely about property, which, as we've established, is how these things went. Let's take a brief detour to the edges of our geographic focus, because Scotland and Ireland had their own legal traditions governing marriage and property, and those traditions produced some variations on the patterns we've been discussing. Scottish law, drawing on both Roman law influence through the Church and native Scots customary law, had some specific provisions regarding marriage and women's property that differed meaningfully from English law. Most significantly, Scots law maintained a relatively robust version of the wife's terce, her right to a third of her husband's property upon widowhood. The terce was more difficult to alienate than the English dower because it attached to property automatically rather than requiring specific assignment at marriage. This meant that women in Scotland had, in some respects, a stronger automatic financial claim than women in England, regardless of whether their individual marriage settlements had made specific provision for them. Which meant that the economic incentive to manipulate a wife's legal status was slightly different. A Scottish husband who wanted to dispose of his wife's assets faced a legal landscape in which those assets were somewhat better protected than in England. This doesn't mean it didn't happen. It happened everywhere. But the mechanisms were slightly different. Ireland, during the medieval period, operated under a complex dual system in which Gaelic Brehon law existed alongside the gradually imposed English common law, and the two systems interacted with each other in complicated ways. Brehon law, the traditional Irish legal system, had provisions for women's legal status that were in some ways more favorable than either English common law or the Canon law that governed ecclesiastical matters. Brehon law recognized female property ownership, female inheritance in certain circumstances, and a form of divorce that was relatively accessible and relatively fair to women compared to the English and Canon law systems. When English common law was imposed on Gaelic Irish areas, which happened gradually over the medieval and early modern periods, the transition was often damaging to women who had previously operated under Brehon protections. The colonization of Ireland by English law was, among its many effects, a colonization of women's legal options. The shrinking of the legal space available to Irish women as Brehon law was pushed out by common law is a history that deserves more attention than it usually gets. It is, in miniature, a version of the larger history we've been telling all evening. The law expanding and contracting around women's personhood, according to forces that were almost entirely outside their control. Let's spend some time with specific cases that are better documented than most and allow us to see the full shape of the experience. We've already met Agnes of Stratton and Margery and Adeliza. Let me introduce you to a few more women whose cases are preserved in enough detail to be worth examining closely. The first is Elizabeth Clare. Elizabeth Clare appears in the Paston Letters, that extraordinary collection of correspondence from a 15th century Norfolk family that provides one of the most detailed pictures of English provincial life in the late medieval period. Elizabeth was a relative of the Paston family, and the letters discuss her situation with a frankness that official court records rarely achieve. Elizabeth had been married to a man who treated her, by the family's account, very badly. The letters describe arguments, financial mismanagement, and what sounds, in the careful language the correspondents use, like extended psychological and possibly physical mistreatment. Elizabeth's situation was not one of legal death. Her husband was not absent, not declared dead, not seeking to replace her. What he was doing was managing her legal non-existence very efficiently while she was still in the house. Because under coverture, she had no independent legal standing. She could not leave. She could not take her property. She could not appeal to a court on her own behalf without his cooperation, which was not forthcoming. The family's correspondence about Elizabeth is a portrait of people who understood the situation, cared about her, and had very limited tools to help. They could offer moral support. They could occasionally intervene in property disputes. They could write letters to each other expressing concern. But the law had arranged things so that the thing she most needed, the ability to act independently in her own interest, was precisely what she couldn't have. Elizabeth Clare is not a case of legal death in the technical sense. She's something more common and in some ways more devastating, a legal ghost who was still required to live in the house she was haunting. The second case is that of a woman known only from a Scottish church court record of the 16th century, identified in the records as Jonet Smith. Jonet's husband had gone to sea, which was common enough in coastal Scotland, and had not returned. She waited 2 years. She then began to keep company with another man in the village. The church court, informed of this by neighbors, summoned her. She appeared. She explained that her husband had been gone for 2 years and was widely believed to be dead. She had heard nothing from him. the ship he had sailed on had not been seen. The court asked whether she was certain he was dead. She said she was not certain, but that she believed it to be likely. The court explained that belief, however reasonable, was not sufficient grounds for the formation of a new relationship. She asked how long she was expected to wait. The court said she should wait until she received definitive news, or until the appropriate period of presumed death had elapsed. She asked who was supposed to support her during this waiting period. The court said this was not within its jurisdiction. She asked if the man she was keeping company with could be held responsible for her support in the meantime. The court said absolutely not, since that would imply recognition of a relationship that had not been sanctioned. She appears to have said something at this point that the scribe recorded as a generalized expression of frustration. She was formally admonished. She does not appear again in the surviving records. Jonet Smith's case is not technically about legal death. It's about the simple, quiet cruelty of a system that acknowledged no legal limbo but also provided no practical support to people living in it. 57. The third case brings us into the early 17th century, and it's one of the most fully documented examples of the legitimate return from legal death in the English record. Her name is Anne Green. Anne Green is actually famous, though not for the reason we are discussing tonight. She was a servant girl in Oxfordshire who was hanged in 1650 for the murder of her illegitimate infant, a charge that appears, from subsequent investigation, to have been false or at least vastly overstated. She was hanged. The hanging was observed. She was cut down. She was taken to Oxford for a medical dissection, as was standard practice with executed criminals. And when the doctors opened the coffin, she was breathing. She was alive. She had survived the hanging. The doctors, who were not entirely unsympathetic to this development, worked to revive her. She recovered. And then the legal question became, what was she? She had been hanged. She had been formally executed. She was legally dead. But she was breathing. The case attracted enormous attention, partly because it was medically remarkable and partly because it raised genuinely interesting legal questions that the courts had never quite confronted in this form. After considerable deliberation, she was pardoned. The king and his council decided that her survival was either a miracle or at minimum a strong indication that God didn't want her executed, and they issued a formal pardon. She was, legally, restored to life. She married afterward, had children, and lived for another 15 years or so. Anne Green's case is the legal resurrection in its most literal form, a woman who was executed, declared dead, and then declined to be. The specific mechanisms we've been discussing, the civil death doctrine, the presumption of death after 7 years of absence, the coverture-based suspension of female legal personality, all of these persisted well into the modern period. Civil death as a penalty for criminal condemnation survived in France until the Revolution, was revived by Napoleon in modified form, and wasn't fully abolished in French law until 1854. In England, coverture persisted in its essential form until the Married Women's Property Acts of 1870 and 1882, which gave married women the right to own property separately from their husbands. Not 1282. The 7-year presumption of death, in modified form, is still part of the law in many common law jurisdictions, including England and Wales, where the Presumption of Death Act 2013 updated but maintained the fundamental framework. The women we've been talking about tonight were not ancient history. The legal framework that made their situations possible was, in most of its essential features, still fully operational 400 years after Margery was crying in churches and arguing with bishops about her right to her own life. The specific flavors of injustice changed. The mechanisms became more refined, more procedurally complex, occasionally more accessible to women with resources. But the underlying structure, the law as a framework built around male legal personality with women located in the margins, remained. The women's legal reform movement of the 19th century, which eventually produced those property acts and other expansions of women's legal standing, was not motivated primarily by concern for the specific situations we've been discussing. It was motivated by the situations of bourgeois women in urban industrial society who found themselves unable to manage their own earnings, their own inheritances, their own lives, under a coverture doctrine that had been designed for an agricultural property-based economy that no longer existed in the same form. But the arguments they made drew on the same fundamental point that Agnes of York and Margery and Adeliza and Jonet Smith and all the others had been making, in various ways, across the centuries. That a woman was a person. That her legal existence should not be conditional on her relationship to a man. That the law should protect her interests, not merely his. These arguments had been available for as long as there were women navigating a legal system that refused to acknowledge them. The difference in the 19th century was that there were enough women making them, loudly enough, with enough access to print and public discourse, that the system eventually moved. Slightly. Let's do a final survey before we let tonight's story drift to its close. We've been asking, all evening, what happened to women who were declared legally dead or whose legal status was manipulated or erased or suspended? The honest answer, as with most honest answers in history, is it depended. It depended on class and resources. A woman with significant dowry assets and natal family support had the legal tools and the practical resources to contest her situation. She might spend years in litigation. She might win a partial victory. She might, in cases like Berenguela, turn her legal disruption into something like political advantage. A woman without those resources had very few options. She could work within whatever institution she had been deposited in. She could find a patron. She could, like Agnes of Stratton, disappear into a different name and a different life. She could simply wait. It depended on jurisdiction. In some places, the legal framework was slightly more favorable. In some periods, courts were slightly more receptive to women's claims. In some specific cases, individual judges or bishops made decisions that were unexpectedly generous. It depended on luck. Whether the key witnesses survived. Whether the relevant documents could be found. Whether the husband's new wife was sympathetic or hostile. Whether the political climate at the time of the challenge was favorable or not. And it depended, in the end, on something that doesn't show up in court records, on the individual woman's assessment of what was possible and what was worth the cost. Some women decided the fight was worth it. Some women decided it wasn't. Some women didn't have the option to decide. There is a way of looking at these histories that is relentlessly bleak. All these women navigating a system designed to ignore them, most of them failing to overcome it, most of them forgotten, most of them leaving only a trace in a court record or a letter fragment or a petition that was filed and never answered. That is one way to look at it. But here is another way. Every one of these women existed. Every one of them moved through the world with intentions and preferences and capacities that did not disappear simply because the law declined to acknowledge them. Agnes, who picked a new name and a new village and got on with it. Matilda, who turned her unwilling entry into a convent into an abbacy. Berenguela, who converted the annulment of her marriage into a platform for governing two kingdoms. Isabel de Chartres, who went to court and won. The three women in the Canterbury Priory, who hired a lawyer and asked for their money. Jonette Smith, who expressed generalized frustration at a court that had no answers and then walked out and presumably managed somehow anyway. Margery, who cried until bishops paid attention. Anne Green, who survived being hanged. These women didn't have access to the legal recognition they deserved. But they were there. They were doing things. They were navigating and arguing and adapting and persisting. And their persistence, quiet and undramatic as it mostly was, is its own kind of history. History has a way of assigning significance after the fact. The women we've discussed tonight were not, mostly, considered significant in their own time. They were problems to be managed, or cases to be adjudicated, or residents to be maintained, or legal puzzles to be sorted out. Some of them became footnotes in legal treatises. Unnamed case precedents, referred to by jurisdiction and date. Some of them left behind their documents, not because anyone preserved them with care, but because they happened to be bundled into archives of larger institutions that survived. Some of them left nothing at all, and we know they existed only because their absence is visible in other people's records. A husband who remarried implies a first wife. A dowry that appears in a dispute over forfeiture implies a woman who brought it. A convent with an unusual number of residents, described as voluntary retreatants, implies a system that was placing women there. The traces of the legally dead are often, fittingly, the traces of absences. The space where they should have been, in the record, is itself a kind of testimony. Modern historians have been slowly, carefully reconstructing these lives for the last several decades. It's painstaking work. It requires reading thousands of pages of court records in Latin and Norman French and Middle English and Low German and Castilian, looking for the cases that don't fit the normal pattern, the petitions that were unusual, the proceedings that went sideways. And bit by bit, the picture fills in. Not into a single story. Into many stories. Into Agnes and Margery and Adeliza and Jonette and Matilda and Isabel and all the others, hundreds of them, thousands probably, scattered across the centuries and the jurisdictions and the varying languages of medieval and early modern European law. Women who were told they were nobody and who in response did various things. Some of them accepted it, some of them fought it, some of them found ways around it, some of them simply endured it until it was over. All of them were somebody. All of them were there. We've covered a lot of ground tonight. We've moved from the basic legal architecture of female personhood in medieval Europe to the specific mechanisms of civil death and presumed death. We've traced the Church's complicated and incomplete attempts to protect women while maintaining the indissolubility of marriage. We've looked at the economics of dowry and dower, the practical politics of the convent, the specific disasters of the Crusaders' wife and the traitor's wife and the wife of the man who just decided to stay in Danzig. We've watched women argue, petition, disappear, return, adapt, and occasionally win. We've watched the legal framework shift, slowly and incompletely, over the course of 8 centuries. And we've noted, quietly, that the essential questions these stories raise about who gets to be a legal person and under what conditions and at whose discretion are not entirely historical. They have echoes. You can hear them if you listen. But that's a different video. The clock suggests it's late. Which is, of course, the whole point. So let's not end yet. Let's drift into a few more corners of this history, the smaller and stranger ones, the ones that don't quite fit the main pattern but are too interesting to leave out. Let's talk about the women who declared themselves legally dead. Because it happened. Not frequently. Not with institutional support. But there are cases, scattered through the records, of women who used the existing legal infrastructure of civil death not as something done to them, but as something they did themselves. The mechanism most commonly available was, as we've noted, the religious profession. If a woman took solemn vows in a religious house, she was legally dead to the world. Her property transferred. Her marriage, if she was married, was dissolved, with her husband's consent or under exceptional circumstances without it. Her civil personality dissolved. And she gained, in exchange, the legal protection of the church, the economic stability of the community's collective resources, and, importantly, freedom from her husband's legal authority. For some women, this was not a sacrifice. It was a strategy. There are documented cases, though their number is hard to establish with precision, of women who arranged their own entry into religious life as a way of escaping intolerable marriages. The process required some resources. Monastic dowries cost money. Finding an abbess willing to receive a married woman required connections. But for women who had those resources and those connections, the option was real. And the husband's position, once the wife had been professed, was genuinely difficult. He could contest the profession on grounds that it had been made without his consent. But contesting it required him to argue in an ecclesiastical court that his wife had not genuinely sought the religious life, which required him to argue, in effect, that she had committed fraud upon a religious institution, which was not a comfortable position. It also, practically, required him to want her back badly enough to pursue the proceedings, which was not always the case. Some husbands, confronted with a wife who had essentially elected to legally die as an escape from the marriage, concluded that the situation, while irregular, was not entirely inconvenient. They were already effectively free to remarry. The wife was out of the way. The ecclesiastical courts were notoriously slow. Why not just let it lie? The woman who arranged her own legal death as a form of self-rescue occupies a peculiar position in this history. She is using the same mechanism that had been used against women for centuries. She is deploying it intentionally in her own interest. She is, in a sense, turning the system's logic back on itself. And she is achieving something that the formal legal structure would never directly give her, a way out. Let's drift into the world of the crusading period one more time, because there's a specific sub-story there that we haven't fully explored. The women who went on crusade. Not as a topic in general, though that's a rich one. But specifically, women who went on crusade and disappeared, and what happened to the husbands they left behind. Because women did go on crusade. Not in great numbers. Not as combatants, in most cases, though there are accounts, contested, of women fighting in crusading armies. But as wives accompanying husbands. As wealthy widows funding and joining expeditions. As religious pilgrims. And some of them didn't come back. The ecclesiastical problem of what happened to a man whose wife had died or disappeared on crusade was, canonically, less complicated than the reverse. A man was, under canon law, more straightforwardly the head of the household, more clearly the primary legal party in the marriage. But it was still a problem. And the cases of men petitioning for the presumption of death of absent crusading wives exist in the records. They are rarer. But they are there. And they reveal, by inversion, something about the standard cases. The rhetoric used to describe the absent wife, when it was the husband seeking the presumption of death, is subtly different from the rhetoric used to describe the absent husband in the standard case. The absent husband is described as potentially in captivity, or delayed by adverse circumstances, or the victim of forces beyond his control. The absent wife is more often described as simply gone, as if disappearance was less surprising for a woman than for a man, as if she had less gravitational claim on existence. Here is one more story before we begin to find our way to the end of tonight. It comes from the archives of a Cistercian monastery in Burgundy, and it dates to the late 12th century. It is not a court record. It is a narrative written by a monk, probably as an example of divine justice for use in sermon preparation. The monk's narrative is about a woman he calls, in the Latin, quaedam matrona, a certain noblewoman. He does not give her name. He is interested in the moral of her story, not her biography. The noblewoman's husband had arranged for her to be placed in a convent. The monk doesn't explain the husband's motivation. He simply says that the husband wished her out of the way and arranged for her to be resident in the house. She was not professed. She was simply there. She was there for 12 years. During those 12 years, the monk says, she prayed constantly. She was not bitter, he says, though I notice he feels the need to mention this, which implies the question arose. She served the community with what he describes as remarkable patience. Her husband died. His children by another woman, it is implied though not directly stated that he had remarried in her absence, came to the monastery and attempted to prevent her from receiving any portion of the estate. And here the story takes the turn the monk wants. The abbess, who had known the woman for 12 years, testified on her behalf. The local bishop, who owed the monastery a favor of some kind, intervened. Her claim to her dowry was upheld. She left the monastery. She used the recovered dowry to found, or help found, a small hospital in the nearby town. She died, the monk concludes, in odor of sanctity, which is the medieval way of saying she was widely considered holy, or at least very good. The monk tells this story to illustrate divine justice, that God restored to the patient and pious woman what had been unjustly taken. But if you strip away the theological frame, what you have is a practical story about an abbess who kept careful records, a bishop who was diplomatically useful, and a woman who had spent 12 years building relationships and a reputation in an institution that turned out to be more powerful than the people who had put her there. She didn't wait for God to fix it. She worked the social infrastructure available to her until the infrastructure delivered what she needed. Divine justice, in this particular case, had a lot of help from institutional knowledge and the right ecclesiastical friendship. It's late now, or early, depending on your perspective. The specifics are getting soft around the edges, which is where we want to be. We've spent a lot of time tonight in the medieval legal record, in the ecclesiastical courts and the civil courts and the chancery and the Parliament of Paris. in convents and royal households and provincial manor houses. In the careful language of petitions and the less careful language of monks writing down stories about divine justice. What ties all of it together is simpler than any of the legal structures we've been discussing. It's the question of who gets to exist. Not physically, obviously. These women were walking around, breathing, eating, managing estates or doing laundry or running scriptoria or crying in churches. But legally, institutionally, in the record, who gets to be a person in the formal sense? The answer, for most of European history, was it depends. It depends on whether you are attached to the right man. It depends on whether that man decides to keep acknowledging you. It depends on whether the institutions around you have an interest in your existence. And the women we've been discussing tonight were the ones for whom that calculation, one day, came out wrong. Who found themselves declared nobody by a court or a husband or a set of circumstances that the law acknowledged as equivalent to death. What's striking, looking back across all of them, is how persistent the impulse toward existence was. Nobody told these women that the right response to being declared legally dead was to keep fighting. There was no handbook. There was no support network in any formal sense. There was no feminist legal theory to give their grievances a name. There was just, in individual case after individual case, a woman who had been told she didn't exist and who looked at that determination and found it, for various reasons, unpersuasive. And who did something about it. Agnes, who found a new name. Matilda, who found a vocation. Berenguela, who found a kingdom. Isabel, who found a lawyer. The women in the Canterbury Priory, who found each other and then found a lawyer. Jonette, who found frustration and expressed it in a way that a monk felt worth recording. Anne Green, who found, against all available evidence, that she was still breathing. History is, in the end, mostly the record of what institutions did. Not people. Institutions. The church. The state. The law. The army. The economy. These are the forces that generate documentation. These are the structures that persist and accumulate archives and employ scribes to write things down. And the people who lived inside those structures, who navigated them and were shaped by them and occasionally pushed back against them, appear in the record only when the structure bothered to notice them. Women appear in the medieval record mostly when they were being managed. When they were being married or widowed or declared dead or put in convents or argued over in court. The rest of their lives, the daily texture of existence, the interior experience, the choices they made in the spaces between the records, are mostly gone. We see them at the moments when the institution's gaze fell on them. And from those moments, we try to reconstruct the whole. It's incomplete, obviously. It's always incomplete. But the incompleteness is itself a fact. The gaps in the record are evidence of something, just as the presence of a woman in a court record is evidence of something. The silence means she was there but not seen. Let the room get quiet now. The details of the Canterbury Court records, the 7-year rule, the Tridentine reforms, the wife's separate estate in Chancery, all of that can settle and soften. What remains, if you let it, is just the image. A woman who has been told she isn't there. Who looks at the legal document declaring her non-existence. And then does something anyway. Sometimes the something is spectacular. A kingdom. A legal precedent. An abbacy. Usually the something is smaller. A petition. A letter. A new name in a different town. A small piece of land granted to a monastery, with a prayer attached, by someone the records describe as a widow without being entirely sure. Small acts of persisting. In the face of official declarations that there was nothing to persist. That is the history we've been telling tonight. It's not a triumphant history, exactly. But it's not a defeated one either. It's a history of ordinary women in impossible situations, doing what they could with what they had. Which is, in the end, most of history. Just most of history. Alright. We've been here a long time now. The candles, metaphorically speaking, are burned quite low. The legal records have been folded and returned to their archival boxes. Agnes is in her new village, with her new name. Matilda is in her chapter house, governing with the quiet authority of someone who was told she didn't exist and found this assessment unhelpful. Berenguela is in Castile, managing the succession of 2 kingdoms with the focused patience of a woman who has been waiting for this moment for a very long time. Isabel de Chartres is counting her recovered dowry, probably not with satisfaction exactly, but with the specific relief of someone who has been through a 7-year legal proceeding and come out the other side with something. The women in the Canterbury Priory are waiting for their money. Jonet Smith has said what she thinks and left the building. Adeliza has granted her piece of land to the monastery, and the candle she lit for her husband is burning in the dark. Anne Green is alive. Sleep is, in its own way, a kind of legal death. You disappear into it. Your legal personality suspends. You cease, temporarily, to be a participant in the world. And then you come back. Every morning, you come back. Restored, more or less, to where you were. It is not the same as what we've been discussing tonight. But there's an analogy there, somewhere in the warm and sleepy logic of almost asleep. The disappearance. The return. The simple fact of still being there. Good night. Or good morning. Whoever you are, wherever you are, whatever your legal status. You are here. That's enough. That's, in fact, quite a lot.